Senate Judiciary Committee will come to order. The clerk will call the roll.
One moment, please, Mr. Chair. Mr. Chair, you have a quorum.
Okay, thank you. The first bill.
Mr. Chair,
Yes,
can I,
yeah.
a couple of things
Yeah,
to start
Senator
with.
Deeds, uh-huh.
We're going to try to do most of the bills in full committee from here on out, but there are a few bills that are going to go to subcommittee. The subcommittee, we have an additional problem this year. Ordinarily, we'd just have to look for space, but we have to have a space where we can provide a virtual forum so people can participate virtually. So I would expect the Civil Law Subcommittee to meet in this space next Monday at 8 o'clock. The Criminal Law Subcommittee will meet on Wednesday afternoons, and the full committee will only will hear bills for an hour and a half. From there on, it'll be the Criminal Law Subcommittee. There will be a couple of changes. The Civil Law Subcommittee will be chaired by Senator Peterson, Senator Lucas, Senator Obenchain, Senator Boysko, Servell, Stewart, Edwards, and Deeds. The Criminal Law Subcommittee will be chaired by Servell, and we'll have Morrissey, McClellan, McDougall, Norman, Stanley, Deeds, and Edwards. There are some bills that will go by today, primarily at the request of the patrons. 418 from Senator DeSteff, 730 of Senator Lewis, 412 and 642 for Senator Morrissey, and the bill I've got is 713. Without objection, Mr. Chairman, I'd ask that those bills go by.
Okay, thank you. All in favor of the motions? I think we have to go on the board, don't we?
Thank you.
You have to go on the board. All in favor of the motions, vote aye. Do you have to push it? Does it have to go on the board? No, okay. Voice vote, okay. So, the very first bill. Okay, all right. We're going to acknowledge Senator Deeds, the co-chair of the committee with me. The first bill is Senator Hashmi.
He's on our way down.
Is that right?
We have Senator Marsden here presently.
Yeah, Marsden. Okay, Senator Marsden. Okay, Senator Marsden.
Thank you, Mr. Chairman. I have two bills. Start with 546, if we could. Senate Bill 546.
546. Senator Marsden, 546 on page 1. Trespass of hunters.
Page 2.
No, 546.
At the top of page
Okay, I'm
2, Mr.
sorry.
Chair.
Okay. It's the bottom page 1 and top of page 2. All right. Senator Marsden, Department of Juvenile Justice.
There you go.
Boot camps.
This comes to us from my friends over there that this bill strikes all references to juvenile boot camps in the code and effectively eliminates juvenile boot camps as a dispositional option for addressing certain delinquent offenses, removes the department's authority to establish or contract for such facilities, and relieves the Board of Juvenile Justice of its duty to prescribe standards for such facilities. This proposals would make other conforming changes. Boot camps have become the equivalent of leeches in the medical profession. They've been horribly unsuccessful, made things worse, made kids worse. We don't do it anymore in Virginia. It's hardly done anywhere. And having to keep up with some of the paperwork required in updating standards and what have you for things that we no longer do doesn't make sense. The good news is that in 1997, there were 1,500 kids in juvenile corrections in Virginia in 8 facilities. Today, we're under 200.
Okay.
Some of them in one facility at Bon Air, and the rest.
Mr. Chair, this language just does away with boot camps. We don't have any boot camps in Virginia anyway.
This is correct.
Is there any opposition to the bill?
Motion made and seconded. All in favor of the bill to do away with boot camps, vote aye. All opposed, no.
Ayes 11, noes 2.
Okay, Senator Lewis, yeah, the bill passes.
Well, thank you, Mr. Chairman. Now we're on to Senate Bill 536, and I'll be out of your hair.
Okay, Senator Marsden, 536, trespass by hunters. Okay, Senator Marsden.
Thank you. Senate Bill 536, a property rights bill. Trespass by hunters. This is increases from a Class 4 misdemeanor to a Class 1 misdemeanor, the penalty for the crime of trespassing while hunting, and an increase from a Class 3 misdemeanor to a Class 1 misdemeanor, the penalty for a first violation of the crime of trespassing while hunting with dogs. It also provides some clarifying language that says a second offense is not a violation, but upon conviction of a second offense, which is current code, which probably is not controversial and is clarifying. The other two parts of the bill raised from a Class 4 to a Class 1 misdemeanor for regular trespassing while hunting, and then a Class 3 to a Class 1 misdemeanor for releasing dogs on lands of another. I spent a lot of the off-season talking with landowner groups. They've gone to websites where they're creating to deal with this ongoing problem of dogs being dumped onto their properties. And I think this is a way of sending a serious message that we support the rights of landowners, and that you can still hunt, you can still retrieve, but to allow the abuses that are going on right now. The confrontations between landowners and hunters have become serious. We dealt with a bill already this year because people are snaring hunting dogs. They're shooting them with arrows, they're shooting them with guns, the tension's getting high. I think we need to do something about it, and this is the first step.
Yeah, Senator Dees.
But this bill applies to people who aren't hunting with dogs as well, doesn't it?
Well, the one half of it does. The one with regular hunting is a Class 4 to a Class 1. And then the other part of the bill is on the releasing of dogs.
So what's your justification for increasing it from a Class 3 to a Class 1?
Or Class 3 to a Class 1 is that nobody takes it serious. It's almost being able to do it with impunity.
Mr. Chairman,
Yeah, Senator Obenchain.
so it's the judges who aren't taking it seriously.
It's law enforcement that, there's just Class 3.
So you think judges should increase the penalties?
Judges should not increase the penalties, but the charges that
You
a
wanna
Commonwealth
increase
attorney
the
can bring,
penalties.
or the Department of Game and Inland Fisheries can bring, I believe should be more serious to deal with this ever-increasing problem.
Okay, Senator Obenchain. Chairman Norman,
Thank you, Mr. Chairman. I remember when Senator Marsden started down this path, and we're only going to make it a Class 4 or a Class 3 misdemeanor. That's really not going to impact people too much. It'll send a message. This is a classic case of where the camel got its nose under the tent and all of a sudden got pregnant, and now it wants to increase the punishment.
Mr. Chairman, Senator Norman, I don't believe that was any of the bills that I carried. Most of the things that I've tried to do are to prevent people from releasing dogs on public roads where the dogs have no place to go but to interfere with people's property rights. I've been unsuccessful.
okay. All right, anybody else have any questions of the patron? Yes, Senator Morrissey.
Good morning, Senator.
Good morning.
I am told that there are approximately 180,000 people who hunt with dogs in Virginia. Would you agree with that?
Who might be what?
Who hunt with dogs in the Commonwealth?
That's a bigger number than I've heard, but I've heard 90,000.
All right. Follow-up question.
Go ahead, Senator Morrissey.
You indicate that we need to increase the penalty from a Class 3 misdemeanor, which is simply a minor fine, to a Class 1 misdemeanor, which would allow incarceration up to 12 months, correct?
That's correct.
You indicated that in your remarks that it was a problem.
That is correct.
My research, and correct me if I'm wrong, has told me that since 2019, there have been a total, over the last 3 years, a total of 11 summons issued in total. 10 summonses in 2019, 1 in 2020, and 0 in 2021 throughout the Commonwealth. Would you agree?
I certainly take your word for that. Nobody takes this seriously. Commonwealth attorneys, local sheriffs. The only thing that Department of Game and Inland Fisheries has taken up is writing parking citations for people leaving their cars on the road. But people are shooting down the roads. We're getting reports of that because they park their trucks, stand outside the trucks and wait for the dogs to flush a deer across the road where they can get a clear shot. It's dangerous,
Chair.
and they're just trying to get people to take it
Anybody
seriously.
like to speak?
Final question, Mr.
Before the-
Chairman.
Senator Morrissey, go ahead, quickly.
So by increasing it from a Class 3 to a Class 1, there will all of a sudden either judges or law enforcement will begin taking it seriously?
I certainly hope they'll take it more seriously.
Yeah, Senator Deeds?
Senator Marston, I'm in court in the western part of the state when we're not down here 3 or 4 days a week, and I defend these cases regularly. And your description of the work just isn't what I see in the western part of the state. I mean, these conservation police officers regularly bring trespass charges.
Yeah, Senator Deeds, this is mostly a problem with the dogs.
In Fairfax County?
It is a problem in Central Virginia, the Middle Peninsula, Northern Neck, and Southeastern Virginia, Southampton County. Senator Deeds, I have people sneaking into my office hoping that they won't be seen by local people from their county coming in to talk to me because they're assuming that people will know that they're there to talk about hound hunting. And it's a serious problem. We've had one stabbing on the Northern Neck between, a landowner and a hound hunter. I just feel it's my responsibility as a member of the Ag Committee, to deal with this issue and to bring it forth as to how the committee reacts to it. It is certainly up to you.
Do you have any
But
speakers?
the one thing I would ask, if you're not disposed to pass the larger parts of the bill, the releasing the dogs on the property of others is the more serious of the two issues, is to at least accept the language on that shouldn't be a second violation, it should be a second conviction.
Okay, is there anybody want to speak in favor of the bill?
For those attendees in the Zoom room who would like to speak in favor of the bill, please raise your hand
Well-
electronically now.
On Zoom.
Mr. Chair, we do have one speaker. Brittany Hartsock, please unmute and begin your testimony. Brittany Hartsock, would you please unmute and begin your testimony?
Hello, I'm actually here for
thank you,
SB
Ken.
113 and SB 114. I'm not for sure why my camera said that I was here for this bill, but I'm here for the SB 13 and SB 114.
Anybody want to speak in favor of this bill, Senator Marston's bill, which is Senate Bill 536? Anybody for 536?
You really would.
Nobody?
None, Mr. Chair.
Okay, anybody here in the audience who would like to speak one way or the other about the bill? Okay, is there a motion?
Move to PBI.
Been moved and seconded to pass the bill by indefinitely. All in favor of the motion, vote aye. All opposed, no.
Ayes 14, noes 1.
Ayes 14, noes 1. Bill, good try, Senator Marston.
I'll crack this code one of these days. Thank you, Mr. Chairman.
Okay. Yeah, Senator Hashmi, you have a bill?
Thank you, Mr. Chair. If committee members will recall, a couple of weeks ago, we brought SB 262, the bill to decriminalize psilocybin, and the committee members asked that we come back with an amendment, and we have an amendment that we'd like to present to the committee.
All right.
Thank you.
Is there a motion to adopt the amendment? Been moved and seconded to adopt the amendment. All in favor say aye. Aye. All opposed, no. Motion carries.
Thank you.
And Mr. Chair, we also have a letter of support from Dr. Sifu, who is medical director at VCU and works in the Veterans Administration Hospital.
Okay.
So, Mr. Chairman, the committee members asked for a little bit more structure in terms of the ability to obtain and use psilocybin for medicinal purposes, primarily to treat PTSD as well as depression issues. You may recall that we heard a lot of testimony from physicians, researchers, individuals who work with folks who are struggling with PTSD, primarily also from our veterans, and that the research around psilocybin shows that it is effective in a therapeutic process in addressing a variety of concerns. And we worked hard with Mr. Quagliato to try to determine how to create an effective structure that would respond to the requests that the committee members had made. And our initial draft was to create a full formal structure in the same way that our cannabis legislation had followed, but that, I think, would have been overwhelming to the process and perhaps unnecessary given the limited scope of the ways in which psilocybin is used medicinally. So here we have a simple amendment, I think, on line 64 to include the language that individuals who are using psilocybin for therapeutic purposes would have consulted with a licensed doctor or a physician assistant, nurse practitioner, and that they are working in conjunction with healthcare professionals in consultation to address the issues around their critical needs. And that is the amendment, and I hope this addresses the concerns that the committee members had raised.
Any questions of the patron?
I've got a question.
Yes, Senator Deeds.
So a defense for this would be a person over 21 years old. If they're caught with these mushrooms, they could say, well, I talked to my doctor. And that would be the defense. Or I talked to a physician assistant, or I talked to an osteopath, or I talked to a professional counselor about this.
So, Mr. Chair and Senator Deeds, the bill seeks to really lower the penalty from a criminal offense to a civil penalty of no more than $100. And I think we see across the Commonwealth that individuals who are using psilocybin are very limited in terms of the numbers, and that they are using it for the purposes of therapeutic need to address the issues of clinical mental health issues that they're facing. So while the penalty remains, the goal is to allow our therapists and other folks who work with individuals in need of this product to be able to obtain it in a safe and effective manner.
But, Mr. Chair, but all a person who's charged with this or who was apprehended with this material would have to do is say, I've consulted with somebody. That would be a defense.
Mr. Chairman, if I could assist.
Senator Steve
I'm
Benjamin.
just a lawyer.
Senator Benjamin.
While one could say that they had consulted with someone, that doesn't mean that that defense would be successful. In fact, it would not be. They would be required, I think, to prove that they actually had consulted with somebody prior to being apprehended with the mushrooms.
And Mr. Chair and Senator Deeds, if I could just add, the civil penalty would still remain.
So you're saying even if you consulted with a doctor and who recommends it, you would still have to pay a $100 fine?
The civil penalty remains in code.
Okay. Is this prosecuted at all? Anybody know, Steve?
I've had one mushroom case, and it was a first offender.
I always look forward to Floyd Fest because I get 2 or 3.
Okay. Is there anybody who would like to speak for the bill or against the bill?
Mr. Chair.
Yes, Senator.
Oh, I'm sorry. I defer to Boysko. I'm sorry.
Senator Boysko.
Thank you, Mr. Chair. I want to thank the patron for bringing this up. There is a significant amount of evidence-based studies that show that, one, psilocybin is not addictive, two, that there are significant improvements on people's anxiety, drug and alcohol and tobacco use, anxiety around cancer, as well as post-traumatic stress disorder. I think this is something that really has a lot of potential. I understand this is a small step, but I really appreciate her efforts in bringing this forward. Thank you.
Okay, Senator Morrissey.
I'm sorry.
You have a question?
No, sir.
Okay, Senator Peterson, you have a question?
Yeah, it's a question and maybe sort of merging into a comment. In the civil sub, we heard some very heart-wrenching testimony about 2 hours ago about a gentleman whose wife was killed by a drunk driver. And obviously, drinking too much alcohol can affect the way you operate a motor vehicle. I've never taken mushrooms. I knew people in college that took them. I do think it would impact the way you operate a motor vehicle, not to mention how you use a firearm and things like that. What protections do we have if we're going to make mushrooms more accessible? What protections do we have against operating a vehicle, using a firearm, using machinery? I mean, how do we protect the community if we make this legal?
Senator Ashby.
Mr. Chair and Senator, I'm not familiar with the number of statistics around which we have issues of folks that are driving impaired or have used firearms while taking psilocybin, but I think statistically it's quite low. And in comparison to the opioids that are prevalent and have been causing severe destruction to our individuals in terms of mental health treatments, this is a more responsible and more effective treatment plan. All of the research that I've seen has demonstrated that it is quite effective. 2 weeks ago, we brought our experts and folks to testify. I didn't want to make the committee listen to that testimony again, but we heard quite a bit of testimony from physicians and researchers who speak to the efficacy of this treatment.
Right, and again, I'm not here to debate that, and I'm going to assume everything you say is true. My question is, people that take mushrooms, is it appropriate for them to operate a motor vehicle, or should they not operate a motor vehicle? I mean, that's a yes or no question.
I myself have not taken the medicine, but I'm seeing Senator Surville, perhaps from personal experience, saying no. Didn't mean to put you on the spot, Senator.
He's putting the Fifth Amendment. All right. Senator Ash, anybody else want to ask? Senator Peake, I believe you want to ask a question.
Mr. Chairman, thank you. This may be for legal counsel, but Senator Boysko said that we're taking this small step. Am I correct in that we are taking this from being a Class 5 felony to a civil penalty, summons civil penalty with a maximum $100 fine?
That's correct.
All right, thank you.
Okay, any other questions? Is there a motion? Anybody want to make a motion? Move to pass the bill by indefinitely and seconded with the amendment. Okay. All in favor of the motion, vote aye. All opposed, no. Pass the bill by indefinitely.
Ayes 8, noes 6, 1 abstention.
Okay, 8 to 6, 1 abstention. The motion to pass the bill by indefinitely passes.
Thank you,
Okay,
Mr. Chair.
Thank you. All right, the next bill is, what's my list here?
Mr. Chair, you do have 2 referrals that you could do quickly if you like. Senate Bill 741 and Senate Bill 399, both need to go to general laws.
Okay. All right, these bill, is there a second? All in favor of the motion to pass the following bills by indefinitely? I can't read it. I'm sorry, re-refer to general laws. We have to vote on this. All in favor, vote aye. All opposed, vote no. Okay.
Ayes 15, noes 0.
Okay, Senator Morsi, let's do 113. All right, Senator Morsi, Senate Bill 112. This has to do with the paroles. The Crime Commission is studying parole. Shall we pass this bill by to next year?
Yes, Mr. Chair, I would just add this. There's a lot of work that has been done off-season on this by a lot of interested stakeholders, but I've listened to comments from members of this panel, and I think we're still in that process of reviewing it. It's also it's being studied right now.
Okay,
So
so without objection, Senate Bill 112 will be passed by for the year. Okay, since the Crime Commission is,
Do we have to vote on that?
Clarification is that to be continued.
we continue to next year. The Crime Commission is studying this very issue. All right,
Acknowledging Senator Morrissey's work, I would move that we carry the bill over and write a letter to the Crime Commission to make sure this is included in their study.
okay. All in
Mr.
favor of
Co-Chair.
the motion, I think we have to vote, don't we?
We do, Mr. Chair.
All in favor of the motion, vote aye. All opposed, no. Motion
Mr. Co-Chair,
says, yes.
Ayes 15, no 0.
Senator Morrissey?
This would be the second year of the study,
right.
so it is being studied, but if your letter can emphasize that we.
We're studying, I'm chair of the
moving it over,
Crime
but it
Commission.
needs to be continued to be studied.
Right.
If there are groups that need to be included in that discussion, we ought to provide space.
Okay.
Thank you, Mr. Co-Chair.
All right. Senator Morrissey, Senate Bill 113, custody and visitation, grandparents, mediation.
Mr. Co-Chairs, members of the committee, SB 113 deals with custody and visitation of a minor grandchild. Essentially, SB 113 requires that where a grandparent petitions the court for custody or visitation of a minor grandchild, that it be referred to mediation. This bill would not be in contravention or inconsistent with the case of Troxel versus Granville. That is the essence of the bill, and I could go into the benefits of mediation.
Mr. Chair.
But it's self-explanatory.
Yeah,
Mr. Chair,
Senator Deeds.
I get the bill. I'm wondering, the court right now has the authority to send it to mediation. Why would you mandate it in every situation? Aren't there situations you can envision where grandparents would clearly not be fit?
If the grandparents weren't fit and they asked a circuit court judge or a J&D judge for visitation, I would agree with you that that would not be a situation in a clear case of unfitness to referred.
But,
So,
Mr. Chair,
Yeah, Senator
mediation
Deeds.
would still be required under the terms of your bill, wouldn't it? A referral to mediation. Any case in which a grandparent petitions the court for custody visitation shall be referred.
Right. It's the word shall you're concerned about.
I agree. You're correct. And I am trying to address the situation, Senator, where there is clearly a case where the grandparent has had a long time involvement with the grandchild, is clearly fit, is desirous of having visitation. That's the spirit or of why I introduced this bill. With that said, I agree with you. There could be a situation where it's person is clearly unfit.
Yeah, Senator, I've had similar cases, but I'm not sure the language only passes bill by indefinitely.
I'm sorry, Mr.
Shall we pass the bill by indefinitely?
Why don't we pass it by for the day in lieu of Senator Deeds' comment and see if there's not some.
Okay, without
Better room.
objection, the bill will be, Senate Bill 113 will be passed by for the day. Okay, Senator
Mr.
Morrissey,
Chairman.
Senate Bill 114.
Mr. Chairman.
Yeah.
Mr. Chairman.
Yeah, Senator
I do
McDougal.
think there's some people here in the audience to speak.
Okay.
In person, maybe online,
Let's
so.
go ahead and do that.
Certainly.
Senate Bill 113, the people would like to speak online.
Mr. Chairman, I know there's some here physically to speak.
Is there somebody want to speak? Yeah, somebody physically. Going up. Thank you very much. Your name?
Co-chairs, senators, thank you so much. My name is Mary Breen Brazier. I'm actually here to speak in opposition of the
Okay.
bill.
Opposition. Go ahead.
I'm just asking you here today to pass indefinitely by this bill. I'm also more than happy to speak in opposition to SB 114 when that comes up as well.
Petition of grandparents. Okay, all
Well,
right. But go ahead. Yeah.
Mr. Chair,
Yeah.
your opposition is, to this bill, is that mediation would be mandatory. Is that right?
I believe you could be putting an undue burden on a parent who may already be a widow and be constrained for time if you're asking them to take more time out of their very busy schedule and take a day off work, which also might financially negatively affect them and their children, in order to meet with a grandparent.
Okay, all right. All right, anything else you'd like to say?
No, I'm just ready to
Yeah.
speak in opposition to SB 114 when you get to it too.
Okay, all right. Any other body would like to speak about 113, custody and visitation and mediation?
Mr. Chair, we have 5 speakers online.
Give him a minute.
Okay, go ahead. 5 speakers online.
Brittany Hartsock, please unmute and begin your testimony.
It's maybe 1 minute apiece.
1 minute apiece, Mr. Chair.
Hello, my name is Brittany Hartsock. I'm here to speak on SB 113. I just want to say that my mother passed away when I was 14 years old and my brother was 6 years old. I was very, very involved in my grandmother's life, which was my mom's mom, not my dad's mom. My dad never kept me away from my grandmother. My grandmother taught me so many life lessons that I take to today, and it is very important that each child has that experience as long as the living condition and the person, the grandparent, is in the right mindset. I think that every child deserves to have childhood memories that they can learn and grow with their grandparent, especially if they've already been in their lives. The child didn't ask for the parent to die, and if that grandparent can see their child living through the grandchild, then that's all that they need and deserve, as long as the living condition and the grandparent is sustainable to society.
Okay, thank you very much. Next.
Pamela Price, please unmute and begin your testimony.
Good morning.
Go ahead, Pamela Price, go ahead.
My name is Pam Price, and I live in Glade Spring, Virginia. My son, Andy, who was a Virginia State Police Sergeant, died tragically in April of 2017, leaving behind 3 beautiful children, which are my grandchildren. Before Andy's death, they had stayed with us for days, nights, even weeks at a time. I had cared for my grandchildren since their birth. However, to add to the children's trauma, they were suddenly and inexplicably taken away from us after their father's death. We have been petitioning Virginia courts for visitation for 4.5 years. With the passage of SB 1325 in 2021, we are re-engaging in the court system in hopes of restoring contact with our precious grandchildren. We want them to know Andy's family has not stopped loving them. I believe the passage of SB 113 and 114 will be another positive step in considering best interests of the grandparents.
Okay, thank you.
In my case, we have offered mediation through the court system, but it has not been accepted.
Jennifer Newman, please
Okay,
unmute and begin your testimony.
Thank you, appreciate it. Next.
Good morning. My name is Jennifer Newman. I'm a staff attorney with the Office of the Executive Secretary. Here to note that the Judicial Conference of Virginia for District Courts opposes this bill for precisely the reason that's already been brought to the courts, to the Senate Commission's attention, and that is regarding the requirement for referral to mediation. As the committee may know, the law already requires that there be a referral to a dispute resolution orientation session, which is different than actually referring to mediation. We would ask that this bill not be passed in its current state.
Okay, thank you. Next.
Dr. Teresa Tyson, please unmute and begin your testimony.
Well, I am Dr. Teresa Tyson. I'm a family nurse practitioner and a qualified mental health professional. I have over 33 years of experience. At our clinic, we survey like the ACEs, the adverse childhood experiences that are very stressful and potentially harmful events when they occur below the age of 18. We use these to assess our patients, and these can be like emotional abuse, physical abuse, parental separation, which would involve like the grandparents, domestic violence, substance abuse, and a shift from 0 to 4 on those scores. They're given a 1 for each point that they have. A shift from 0 to 4 increases like the risk of depression, suicide by 1,200%, alcoholism, illicit drug use. And so one of the things that we can do is build resilience in these children. And that would mitigate a long way, because even people that experience these, if they have a 6 on these, they can live 20 years less. And so it's not just here and now, it can affect their long term. So we want to build resilience with the grandparents and keep the grandparents involved in it, because one of the things that we can do is keep attachments. And if children feel connected and, and part of a bigger family, that is a very positive thing for children. And so I'm in favor of the SB 113 and the 114 that'll come up later.
Okay, thank you very much. Next.
Keith Atkins, please unmute and begin your testimony.
Thank you. My name is Keith Atkins. I have not seen my grandson since June 4th of 2020. We petitioned the court 3 times. First time was with Judge Pemberton, and I would like to say that she really tried to get us to have an agreement with the mother. Second time, we went in, and the only agreement that could come out of this was we'd be allowed to send Christmas gifts to my grandson. We never got a response from the mother or nothing. And the third time, the guardian light came in and she spoke, and her testimony was everything from the mother. That guardian light never once contacted us, never came to our house to see what was going on.
Okay.
And it's really.
Okay, thank you very much. Is there anybody else on Zoom?
Mr. Chairman, those are all the hands raised at this
Okay.
moment.
We have somebody behind, yes, Senator Morrissey.
I think the motion was to pass it by for the day to work it out. So if you want to continue this, fine, but I think we can end it here.
Somebody's behind you too that'd like to say something. Okay, your name?
Thank you, Mr. Chairman, members of the committee. Dan Gray on behalf of the Virginia Family Law Coalition. I just wanted to point out, we oppose this bill for the reasons that Senator Deeds mentioned, that the court already has the authority to refer all third-party visitation cases to mediation. The other thing I will point out is that in the latter part of the bill, the law is that the fee of the mediator shall be $100 per appointment, shall be paid by the Commonwealth. This bill says if a grandparent is referred to mediation, the grandparent has to pay for the mediation. So on the one hand, you're requiring that these cases go to mediation, and then you're requiring that the grandparent pay for it, which doesn't seem to us to make a lot of sense. So for those reasons, we would oppose the bill.
Okay.
Thank you.
The motion been made to pass the bill by for the day? Is that right? Okay. Voice vote. All in favor of the motion to pass it by for the day, vote aye. Aye. All opposed, no. Bill passed by for the day. All right, the similar bill is Senator Morse's 114. It's a little
Yes.
more.
Mr. Chair, I'm going to be
Need
brief on this for 2 reasons. One, this bill passed this Judiciary Committee 12-2 last year and the full Senate 36-4. And also, I want to perhaps transfer some of my time to Ms. Holloman, who is going to be speaking virtually right after me, maybe a little bit more than 1 minute.
Okay.
This bill, folks, Mr. Chair, members of the committee, you may recall, requires the court in petitions filed by a grandparent for visitation where the parent is deceased, incarcerated, or incapacitated, or the grandparent has established a relationship with the child, to consider certain factors, such as the historical relationship between the grandparent and the child, the motivation of the grandparent in seeking visitation, the motivation of the living parent in denying visitation, the quantity of time requested, and the benefits of maintaining that relationship.
So, Mr. Chair.
Okay, Senator Deeds.
With these categories of down 46 through 50, you are basically redefining what's in the child's best interest.
I don't know if it's redefining, but simply saying that those factors need to be considered in that situation where the court considers the already established relationship.
Mr. Chair,
Okay, Senator Deeds.
I was struck by the testimony of one of the witnesses to the last bill who talked about the grandparents' best interests. And I wonder if that's really what we're looking at with some of these instead of the child's best interest.
Senator Morrissey, I think it's listed from lines 46 through 50, the factors to be considered.
The language that is being changed is on lines 40 through 50 inclusive, which is the same thing that we considered last year when we passed it 12-2.
Okay. Yeah, Senator Sherrill.
Mr. Chairman, I have a sort of a more fundamental question, I think, for council. And this came up last year, but I know that grandparent visitation starts to run afoul of the Constitution. And I forget the case right now off the top of my head, but there's been a couple United States Supreme Court cases talking about when a court can override a parent's wishes and all that. And so I'm not clear whether, because this new section B3 has to do in cases where the parent doesn't consent. And so we're really towing the line on the Constitution here. I was curious what council's thoughts were about that.
Mr. Chairman,
Yeah,
last
Senator
year,
Christensen.
we passed the language that you see on lines 32 through 39, and that was a result of the work between Senator Morrissey, Senator Donovan, the Family Law Coalition, and other practitioners who determined that that language was within the bounds of the Constitution as it's been interpreted by Williams v. Williams, which is the Court of Appeals, the Virginia Court of Appeals case on the issue. For visitation for children with grandparents or whomever else, the rule is that you first have to find that the child would be unduly harmed by a decline or the court's prohibiting the visitation between the grandparent and the child, and then you can move on to the best interest factors. So in order to skip the step, you infer the consent of the grandparents. I'm sorry, not infer. You look for consent of the grandparents, which is what we provided for on lines 32 through 39, and then you can skip over to the best interest test. A lot of grandparents were being denied visitation because they have to achieve this great hurdle of the undue burden test before they can achieve or before they can come to the best interest test. So Senator Sorrell is right that that Senator Morrissey's language is constitutionally questionable because it seems to allow courts to skip over the undue burden test.
Okay, any other questions?
Mr. Chairman, one other question I
Yeah,
have.
Senator Sherrill.
And sorry, also, one other question I had about the way it's written is that the way it's written, it seems to constrain the court's inquiry to the 5 factors, whereas typically when we have visitation, under our visitation statute, the existing one, you note, it has a catch-all at the end about any other thing the court wants to look at or whatever. And so it seems to me the way this is written right now, it says these are the only 5 things the court can look at. Is that right, the way it's written?
That may be one interpretation of it. I believe that Senator Morrissey's intent was to read it in addition to the best interest factors that are provided for in section 20-124.3, I believe.
Yeah.
Okay, thanks.
Which has that catch-all factor at the end.
This bill passed last year, the Senate.
Well, Mr. Chairman.
Yeah.
Senator Morrissey's right that the bill passed, but it was in its substitute form at the time. The 12-2 vote was for the substitute, which put the language in B2, which you see before you in current code.
The language will B2, okay. Well, that's.
B3 amendment is new language,
Correct.
not considered last year by Judiciary. Is that what you're saying?
It started out, when we saw the bill at first, it started out with the language that we see in B3 right now. During the Judiciary Committee hearings, it was amended so that the language was as you see it now in B2, and that is what passed the Senate passed the committee 12-2 and then passed the Senate.
So you're saying as now written, it passed the Senate. Is that right?
No, Mr. Chairman.
Okay, go ahead.
The language was amended. We started with the language that's in B3 in committee last year. During the committee process, it was amended, and all that language was all taken out, and language was inserted that you now see in B2. That was the agreement between the patron and the practitioners, and that language is what passed the Senate and then was signed by the governor.
So, Mr. Chair, what she's saying is that B2 was the bill, only part of the bill that passed last year. The B3 was excluded before we passed it.
So, but B2 is in the code right now.
That's right. That's what we passed last year.
That was, but I thought the House killed it. Is that right? What happened to the bill?
No, Mr. Chairman, it was passed and it's been enacted into law.
Okay, okay, so, all right, so your bill passed last year, right?
Yes,
Okay.
the language of B2.
right.
B3 is new language.
Right, okay.
Uh,
I see.
Mr. Chair, could we hear from Nancy Holloman, and then there may, I'm
Okay.
not sure what the flavor of this committee is,
All
but
right,
I would like to, you
briefly.
to consider her first.
Okay, Nancy Holloman. Okay, thank you, Nancy. Here she comes.
Chairpersons and members of the committee. My name is Nancy Holloman, and I am a 72-year-old grandmother who is retired from teaching kindergarten in the city of Colonial Heights Public Schools for 43 years. This fall, I returned to full-time teaching in Chesterfield County to help out with the shortage of teachers due to COVID-19. More importantly, I'm a grandparent who has been denied of having any visitation with my two grandchildren due to the current laws in the Commonwealth of Virginia that govern visitation by grandparents. I am here today to urge you to support SB 113 and SB 114 as it pertains to order mediation and visitation arrangements between the grandparents and the grandchildren. I was a single mom left to raise three children ages 5, 14 months, and 2 weeks old. Through much perseverance, I can proudly say I was able to put all three of those children through undergraduate and master's degree programs. In 2006, I was unexpectedly lost my only son, Patrick, who died in his sleep. There's no way to express in words the heartache and the grief when a parent loses a child. In 2011, I was blessed when my first grandson was born. There have never been a more excited grandmother than me. Landon gave me so much joy and renewed hope and purpose in life after my son's passing. I continued to teach each day, leaving at 3 o'clock from Colonial Heights to travel to Goochland County to my daughter's home to be at 4 so that she could go to work. In 2015, when baby Logan was born, I decided to retire from a teaching career, which I loved, and so I could be more available for my precious grandchildren at my daughter's request. For 7 years, I was with Landon and Logan 5 days per week. We formed a special bond like no other, and as I like to say, they were glued to me at my hip. In January of 2018, my daughter, who has been diagnosed with a borderline personality disorder, who is extremely angry and aggressive over a huge amount of money that she owed me. She abruptly stopped me from seeing my two grandsons and prevented me from having any form of contact or visitation with them. This behavior on her part was due to spite, cruelty, and jealousy. She just basically wanted power and control over my life. On February the 9th, 2018, I filed for visitation in Goochland County. Thus began a court saga that went on for 19 months until July 2019 via Goochland Court Circuit Court, where the end resulted in no visitation. Now my grandsons no longer have their mama as their safe haven. As the law currently stands now in the Commonwealth of Virginia, it is almost impossible for any grandparent to receive visitation unless there's testimony from an expert witness. Usually a psychiatrist may be appointed by the court to perform an evaluation of the grandparents, parents, and minor children. At 6 different hearings, my attorney asked for an expert witness, Dr. Michelle Nelson, to perform an evaluation at my expense, and the court in both juvenile and domestic relations in Goochland Circuit Court denied the request. In both courts, the CASA worker appointed by the court to investigate the children and the parents and their volatile home situation was not allowed to testify and report her findings. However, the guardian ad litem, who had no training to determine the emotional, mental, and physical well-being of the grandchildren, was allowed to speak at each hearing to include cross-examination of me and the witnesses. To date, I've been to court 17 times seeking visitation with my grandchildren. I've spent over $100,000 in attorney's fees and have nothing to show for it but a broken heart. If SB 113 and SB 114 pass, these bills will give renewed life and hope to thousands of grandparents and grandchildren in similar situations as mine all across the state of Virginia. In October of 2021, baby Avery was born. She is now 15 months old, and I have not been allowed to even see her or hold her in my arms. I cannot even send any of my grandchildren a Christmas card or a birthday card. I was the best mama any child could ever have. I would like to have a relationship with my grandchildren. I want to be able to take them out to lunch, to get ice cream, to see a movie, to be present at school for Grandparents' Day, to attend school plays, sporting events, and take my grandchildren fishing. However, most of all, I want to be able to give them the love and security they are lacking in their home environment. I beg you to not only support me in an endeavor to change this existing laws of grandparents' rights for visitation, but thousands of other grandchildren who are in desperate need of their mamas. Please remember that this is not a bipartisan issue, but rather a very unfortunate family issue that affects all members of society, all economic levels, both professional and non-professional. I thank you so very much for your time, and please take a moment before you vote on these two bills to reflect and remember what your own experience is relative to your grandparents and grandchildren and what they have meant to you over the years. This is a picture of my two grandsons. I have not seen them now in 4 years, and I now have a granddaughter who I've never seen, I've never been able to hold, never been able to have anything to do with. This is a picture of them when they were 6 and 3, and now it's 4 years later, and I have no current pictures.
I'm so sorry. Yeah, thank you very much. Senator Morsi, does anybody else want to speak one way or the other? Yeah. Okay, very quickly, 1 minute apiece. It's now 10:45. We got to leave at 11.
1 minute apiece, Mr. Chair.
Very quickly.
Brittany Hartstock, please unmute and begin your testimony.
Hello, again, I'm here on SB 113 and SB 114. I'm actually seeing a very good family friend of mine go through the same thing as I've seen other witnesses go through this. She unexpectedly lost her son. She already had a relationship with the grandchild. She worked for the community. She worked for the health wagon. She's always putting others before anybody else, and she's being kept for no reason because of the ex being vicious over them two not working out. And sometimes we do want to do what's best for the children, but sometimes they're being kept because of the other parent not wanting to comply for no reason. And that puts hurt on the child whenever they already had that relationship. Just like whenever people get older, they can't help what happens in life or what their children do. She didn't ask for her son to die, and she suffers every single day. And she needs to see her baby, to see her son live through that.
Thank you.
And just think about everybody else going through that.
Thank you.
Mr. Chair.
Next.
Brittany,
Next.
Deborah Miller, please unmute and begin your testimony. Deborah Miller, would you please unmute and begin your testimony?
Yeah, I'm gonna let my husband talk. This is Robert Miller.
Yes, I have something to say. We're in the middle of a court battle right now to get our grandchildren back. We have not seen them and will not be able to see them for 1.5 years, even though the court ordered us visitation. The people that have them are trying to make us pay $80 an hour for an au pair to come with us to visit. Now, we found out in court the guardian of Lytton lied. She did not come to our house to inspect. CPS did not. However, the CASA woman did, and she said the house was great. But our grandkids got given to people who tested on drugs, meth. We were clean. These kids we've raised for 10 years. They don't know what the heck's going on now, and they were split up.
Let them know what your past.
All right, thank you very much.
I want this bill to be passed for grandparents.
Thank you. All right, the next person, can you keep it to 30 seconds? Because we don't
Pamela
have much.
Price, please unmute and begin your testimony.
30 seconds.
It only gets done to a minute, but we'll hold it to it, Mr. Chair.
30 seconds.
Pamela Price, please unmute and begin your testimony.
Yes, thank you. I spoke a few seconds previously, and I would just like to again say that after my son died, the relationship with my 3 grandchildren was lost, taken away almost overnight. But I believe that grandchildren who have lost a parent benefit from a continued relationship with loving grandparents and is supported and reinforced through the works of many experts. We owe it not only to my grandchildren, but all grandchildren within the state of Virginia to do whatever necessary to give them the security and support of loving grandparents.
Thank you very much. Next.
Jennifer Newman, please unmute and begin your testimony.
Yeah, 30 seconds, please.
Thank you, Mr. Chair and Mr. Co-Chair. My name is Jennifer Newman. Again, I am a staff attorney at the Office of the Executive Secretary. The Judicial Conference of Virginia for District Courts opposes this bill because, in particular, on line 53, it allows a grandparent whose child's rights were terminated to be able to file for custody and visitation. This is inconsistent with the current law regarding the definition of a person with a legitimate interest.
Okay, all right, next. Is there, the people who are here, come on up and speak one way or the other, okay? Your name?
Mary Breen Brazier. I'm sorry. Is it my turn or internet?
Go ahead.
All right. Am I really only on 22 seconds? Awesome.
Well,
So while you guys are mulling over 20-1.2 or 124.2B2, I'm living it. I am probably one of the first people in the state to be sued under this law and have the grandmother win. I would ask you today, well, I have like 3 minutes worth of stuff, but please don't pass this. Please, my family is suffering. I want my rights back as a parent, please.
You do not want the bill, is that right? You do not want the bill?
I'm in opposition.
Opposing the bill, okay. All right, next.
Mr. Chairman.
Yeah, go ahead.
Just as a, we did hear for a long time from the supporters of this bill. I don't want to prolong this, but if opponents have something to say, I am concerned about cutting them off with 30 seconds.
Okay, yeah, come on up.
Mr. Chairman, members of the committee, Dan Gray on behalf of the Virginia Family Law Coalition. Again, we do oppose this bill, and the constitutional issue was raised earlier. Just to clarify, above all of this is the U.S. Supreme Court case of Troxel versus Granville, which said that parents have a fundamental right to control the upbringing of their children.
Okay.
What the Virginia courts have said is that in order to rebut that presumption, that you must show actual harm to the child. That is the test in Virginia for third-party visitation rights. And in our view, this bill is attempting to lessen that actual harm test. We don't think that's in the best interest of the children of Virginia. There is a balancing that needs to be done, but again, our courts have already determined that actual harm is the test, and this bill is an attempt, I believe, to water that down. If the committee was intending to do that, it ought to require a lot more study of that burden.
Am I correct
Thank
that
you.
last year we passed the bill on lines
Mr. Chairman.
32 through 39, B2, that includes the best interest test, is that right? That just went into effect last year.
So B2, we did work with Senator Donovan in order to craft a very narrow exception,
But
yes.
that just became law last year.
It did, and I will note for the committee that has already been subject to constitutional challenge in the Western District.
All right, okay,
So-
thank you. Next.
Thank you, Mr. Chair and members of the committee. Valerie LaRue from Virginia Poverty Law Center. We also oppose this bill. We do believe that it's unconstitutional. And as Mr. Gray noted, it has been challenged on constitutional grounds. However, it hasn't been fully tested because the plaintiffs brought the case too soon and they were determined not to have standing because basically the case wasn't ripe yet. So we would ask that the Senate Judiciary Committee allow that last year's change to the bill to go through the constitutional testing process before making any further changes.
Okay, thank you. Is there a motion? Yes, Senator Morrissey, go ahead, wrap it up.
Could you listen to counsel for a moment to correct a matter?
Sure.
Yes, Mr. Chairman, I wanted
Yeah,
to
Kristen?
apologize to Senator Morrissey. I misspoke when I said that the committee had not passed the language before that he has inserted on lines 40 through 51. It did pass it. It was in 2020. And then 2021 is when the change happens that we enacted last year.
Okay. Yeah, Senator Deeds.
2020, we passed the bill and the House killed it.
That's correct, Mr. Chairman.
Okay.
Mr. Chair.
Yeah, Senator Peterson.
Yeah, I don't do domestic practice, but let me ask a question. Maybe Scott or somebody else knows the answer. If you're a grandparent, and let's say your child dies and you have grandchildren and the surviving in-law, daughter-in-law, son-in-law, denies you access to those grandchildren, you have a cause of action, and if so, how do you go about that? How do you get access to your own grandchildren? What, Scott, how do you do it?
Anybody know the answer
Yeah,
to
Mr.
that?
Chairman, that's different. If the parents have passed away, then
One
the
of the
constitutional
parents
rights of parents, the remaining parent has the constitutional right that has to be honored, and that would fall under subsection B2.
So you would petition, I mean, if the surviving parent says, I don't want you to see that side of the family, you have no right?
Mr. Chairman, I think what council said was that you have to show actual harm to the child by the denial before you can get to
And
the
that's
best
like
interest.
economic harm, emotional harm, what kind of harm? I mean, what if you say, I'm willing to put the child through college, but I need to see them?
Mr. Chairman, I'm not sure it's defined that specifically constitutionally otherwise. I mean, I think emotional harm is usually what people are looking at. I mean, physical harm is obviously gets you in the door. Emotional harm usually gets you in the door as well. So, but I've never litigated exactly the fact pattern you're talking about, but.
Okay. Now, anybody else have any legal questions,
Let me wrap this-
expertise here?
Let me wrap it up,
Yeah,
Mr.
Senator
Chair.
Morsi.
Okay. First of all, to some degree, we have spoken over one another, but let's understand where we stand today. The language that I'm asking this committee to support did indeed pass in 2020, 12-2 in this committee and 36-4 in the Senate. Senator Deeds, you're right, it was then defeated in the House. Now, with regard to the comment about the United States Supreme Court's decision, it is true that Troxel versus Granville was decided in 2000, and it simply, well, not simply, it held that parents have an inherent constitutional right in rearing their children. This, in my opinion, and others' language is not in contravention with Troxel. With that said, what we're trying to get at is the following situation, as Ms. Holloman stated. A situation where grandparent is intimately involved in grandchildren's lives from an early age, 5-6 days a week, several hours a day for many, many years. And because parent has a emotional condition, something happens and just cuts it off, we're suggesting that this language is necessary so that the court can hear it. And what we're talking about is simply the historical relationship between grandparent and child. For that reason and those reasons, I'd ask that the committee pass SB 114.
Okay, is there a motion? Is there a
move to report.
motion? Any motion?
I move to report.
It's been moved and seconded to report the bill. All in favor of the motion to report the bill, vote aye. All opposed, vote no.
Did you not watch the line?
Oh, yes, thank you. There's a technical line amendment that council, I'm sorry.
Okay, strike the vote, strike the vote. What is our technical line amendment?
Mr. Chairman, on line 43, Senator Morsi has asked that we strike "or has had his parental rights terminated," which I believe was in response to the concerns brought by the Supreme Court.
All right, strike on line 43.
43,
Strike.
strike "or has had his parental rights terminated."
Charles?
Who has had his parental rights terminated? Okay, strike. Is there a motion to adopt that amendment? So moved. All in favor, vote aye. Aye. Vote aye. All opposed, no. Okay. All right, now motion to report the bill as amended. Is that right?
That's right.
Okay, all in favor of the motion to report the bill as amended, vote aye. I'm not sure.
Ayes 5, noes 10.
Ayes 5, noes 10. The bill is not reported.
Mr. Chair, I've got a motion that we pass the bill by indefinitely.
Okay, motion to pass the bill by indefinitely. Second? Second. All in favor of the motion to pass the bill by indefinitely, vote aye. All opposed, no.
Ayes 10, noes 5.
Okay. 10 to 5.
Mayor, have we moved on to another bill?
Pardon me, no, I just put the bill number up wrong. That's my mistake, pardon me. Same
Pass
bill,
the-
this is SB 114.
Yeah, 114. Hey,
Sincere apologies, Senator Pete.
It's Senator Morsi's 114. The vote is to pass the bill by indefinitely. All in favor, vote aye. All opposed, no. The motion, okay. We've already done it. We're okay. We're okay. All right, you passed the bill by. All right, Senator Morsi, you may win this bill. Senate Bill 412. I'm sorry, all right. 639.
Thank you, Mr. Chair. Thank members of the committee. SB 639 seeks to address a shortcoming in SB 667, the Good Samaritan Law. Let me just explain it like this. Last year, you all remember passing SB 639. We called it the Good Samaritan Law. That was a situation where an individual who was in the throes of a overdose reported it, that person who reported it or the person who was going through the overdose could not be prosecuted. That bill passed
Chair.
40 to nothing in the
Mr.
Senate.
Chair.
And is somebody talking?
I'm sorry. The Good Samaritan bill was 2015. It's been updated, but the original bill was 2015.
This is
It was
Senate Bill
my legislation.
639. Let's hear the speaker.
Okay.
Senator Morrissey, you have the floor.
So last year, 667, that said, if you see somebody in an overdose and you report it or you're going through it, report it, you can't be prosecuted. It passed the Senate 40 to nothing. It passed the House 59 to 40. It's the law. So right now, if somebody is using with a colleague and that person is overdosing, they call it in, they can't be prosecuted. It covers the person using, the person calling in. Well, at least one prosecutor has sought to get around that. And the person gets it around it. If you'll look at the items that I gave to you, they're now doing a show cause order. And the show cause order says, if you look at it, on such and such a date, Henrico police responded to a medical emergency call involving the defendant. The defendant was found to be in crisis due to an apparent usage of narcotics. The prosecutor is asking the judge to show cause that individual for something they did maybe 3 or 4 years ago and got a suspended sentence. A direct contravention of what the spirit of this law was. This bill corrects it by simply inserting the words on line 14, instead of no individual shall be subject to arrest or prosecution, and now includes the words show cause, probation, revocation, or parole violation.
Mr. Chair.
Yeah, Senator Peterson.
Let me.
Senator Boyce go first.
Mr. Chair, thank you. So I carried this bill in 2020, and I can tell you that when we went to the House, this came up a lot. I can almost guarantee you that if we were to change this, we risk losing the entire
Then let it risk
language.
it. That's not what we want to do. We wanted to save lives.
All right.
That's why we passed this bill.
Okay.
And now, if somebody knows that if they call it in, the Commonwealth Attorney will do an end around and simply show cause them for a previous violation, defeats the spirit of what we tried to do.
Okay.
Mr. Chair,
Senator Boyce,
I would just follow up and say, you know, the reality is what the reality is. I appreciate your effort. I have some trepidation about making these changes, though.
Okay. Senator Short.
Peterson.
No, Senator Peterson. Go ahead, Peter.
Yeah,
Peterson.
well, I was just going to say, I had the bill in 2015 that was the original Good Samaritan law. Betsy Carr had it in the House, which basically started the whole concept of, typically it was a third party. If you were with a friend or somebody that had overdosed and you called 911 and you were underage or illegally possessing, that you were immune from prosecution. Here's my concern, Senator, and that is, let's say you have somebody that's on probation, and maybe they've had a substance abuse issue, maybe they've had a meth problem, maybe they've had a cocaine addiction, and they agree to terms of their probation. One of the terms being maybe they test regularly, which happens all the time. And then they show up at an emergency room having an overdose, and it's a little bit different than, say, somebody calling in a friend. And the problem is, and I understand we want to have this sort of safe harbor idea, but if we're going to basically, if they're going to agree to terms of probation, one of which is I'm not going to use drugs or illegal drugs, and then they use them and we know they're using them, it's not quite the same. I just don't feel it's the same, but feel free to respond.
Sure, let me try to address that. While I won't object to striking probation, revocation, or parole violation for the reasons that you said, if somebody is in the throes of an overdose and the person who heretofore would not call it in because they feared that they or the other person would be arrested and then that we lost that person's life, if they now realize that for another crime, the Commonwealth Attorney can, instead of arresting them, which this law says you can't do now, show cause them for a previous conviction, then they will not call it in.
Okay, let me ask, fair point, but wouldn't a show cause require a pre-existing order for which the subject was subject to that order? Another person has to be subject to a pre-existing judicial order. That's why they would be a show cause.
Yes, a show cause order is requested and would be issued if there is a previous order of conviction. Senator Peterson, would not, for the reason that you suggested, I wouldn't object to deleting probation, revocation, or parole violation. Don't want to, but in order to get this bill passed and include the language show cause, I would be willing to do that.
Okay.
Chair?
Yeah, Senator Boysko.
Thank you. So Senator Morrissey, I appreciate what you're trying to do here. My concern is that this goes over to the House and they completely gut the whole thing and bring it back with an amendment that eliminates all of the protections. Would you, on good faith, agree to, reject the amendments, strike the bill if something goes wrong in the House where they are really hurting the intention of it?
Right now, it is the law that you can, if you call it in and you're ODing or your friend's ODing, you can't be charged. So the only thing the House could do is change my language here, or they could amend it even further. And if they did amend it further, it comes back here and we would reject it. And I, of course, I would support rejecting that. My whole idea is to save lives, and this began when remember that child was in a closet and they just would not report it for fear of being prosecuted.
Senator Stewart.
Joe, I see you've got these capiases from the Commonwealth's Attorney's Office, but what are the courts ruling on these? Are the judges finding them and suspending? What's happening once they get to court? This is just the first step.
Yes, of course.
The Commonwealth's Attorney requesting a capias, but do we know what the courts are doing with these cases?
The only example I have is the capias being approved for arrest of that individual, arrest and incarceration. But I think your question goes to, ultimately, what is the judge doing? I'm going to be guessing, and so I don't want to do that. But
yeah, Senator Stewart.
Shouldn't we find out what the courts are doing before we go amending this law? I've listened to the discussion, and if you put show cause in, then it would indicate that they could do it on a probation revocation or parole hearing or something else that we're not thinking about it. And the law looks pretty clear to me right now. I just would like to know what the courts are doing before.
Yeah, Senator Morrissey.
when you say the law is clear, you mean you're thinking that the judge is simply saying it's violating the spirit and we're not going to do it?
Mr. Chairman?
Yeah, Senator Stewart.
I read it as saying no arrest or prosecution.
Yeah.
And so, just because Commonwealth's attorney issues a capias.
I see.
I'd like to know if the judge is finding them out of compliance or not, or dismissing these cases before I do anything on this
Sure.
bill.
With regard to these specific instances, I'll find out exactly what happened, but it was brought to my attention because the defense attorney was telling me that the courts were acting on it in a manner that was detrimental to the defendant.
All right. Okay.
But I
But
don't know the exact answer, but I will
Steve.
find that out. It's a good one, and I don't mind
Steve.
continuing it over to get the answers.
Mr. Chairman, if I
Benjamin.
could suggest to Senator Morrissey that he also check 19.2-306.1, subsection B, says that if the court finds that the basis of a violation of the terms or conditions was that he was convicted of a criminal offense, then the sentence can be revoked, but this is not that instance, okay? Or that they violated another condition other than a good conduct violation that did not result in a criminal conviction. These capiouses, Senator Morrissey, all allege that it's a good conduct violation, but of course it could not have resulted in a conviction because of the existing law. And so any revocation for a good conduct violation that did not result in a conviction should be void. That should not have happened.
Okay.
And to Senator Stewart's point, I think that if a capious is issued, then when one is arrested on that capious, that is an arrest within the meaning of existing law. So I think Senator Stewart's concern about unintended consequences is worthy of consideration.
Okay, shall we pass the bill by? Any objection to passing it by for the week? Or the day, passing by for the day? Is that okay? Without objection?
Pass it by for the day?
Pass by 6:39, pass by for the day.
Okay, yes, sir.
Without objection?
No, that's not objection. I'll
Okay.
try to get your answer, Senator Stewart, and also,
Joe, I'll help you anyway.
Mr. Benjamin, address your concern of 19.2-306.1.
Senate Bill 642, Senator Morrissey. Okay, by for the day, all right. Now Senator Peake, Senate Bill 163, I think we need an amendment, is that right?
Yes.
Okay. I'm going to read the amendment. This has to do with surrogacy contracts provisions requiring abortions or selective reductions unenforceable.
Mr. Chairman.
Yes, Kirsten.
There are two amendments. First on line 5, after requiring, add or prohibiting. And the second on line 33, after requiring, add or prohibiting.
Okay. Did everybody understand that? Okay, 163. The amendments. All in favor of the motion to adopt these amendments, say aye. Aye. All opposed, no. Motion carries.
Mr. Chair, in amended form, this bill is identical to legislation we passed unanimously last session, so I've moved to report.
2020.
2020.
In
2020, I think. I don't know if I brought it last year, but yeah.
Okay, all has been moved and seconded that the bill as amended be passed. All in favor, any discussion, all in favor of the motions, vote aye. Aye. Vote aye. All opposed, vote no.
All right.
Okay.
Ayes 15, no 0.
You want to roll? Okay, Senator Searle, want to do any of yours?
This bill will have to go to finance and the reports, Mr. Chair.
Yeah, Senator's report order. Senator Searle, do you have one?
Sure, Mr. Chairman.
Senator Boyce Associated Small.
Well, let's see. Who wants to go next, Serval or Boyce go? We got a bunch of bills.
Yeah, Mr. Chairman, mine are not going to be doable in 20 minutes. I don't know if you want to knock some other people
Pass it
out.
by for the day. Senate Bill 348, pass it by for the day. 465, which Senators Boyce
Sorry,
go.
348, 49, 669, and 742 are mine, Your Honor, which would have to go by for the day.
Go ahead. Senator Boyce goes. Senate Bill 455.
All those in favor?
Calculation of gross income for determining child support, rental income.
Thank you, Mr. Chair. This should be, I hope it'll be fast, and possibly the least controversial we've done. This 455 would amend the Virginia Code that pertains to guidelines for determination of child support when dealing with rental income. The Virginia Court of Appeals currently has 5 unpublished decisions addressing what expenses are to be deducted in determining the amount of rental
Mr.
income
Chair.
to be included.
This simply allows you to deduct your expenses if you hold property as an individual. Is there any opposition to this bill?
Does that include salary to yourself?
Rental income.
Rental income, rental income should
It
be
allows
considered for
deduction
child
of
support.
expenses.
Yeah.
How about
Yeah.
salary to yourself?
Yeah.
I don't.
Yeah.
Mr. Chair.
Boyce go, which is all you're saying is rental income should be considered in determining child support, correct? That's the bill. All right. Is
Correct.
there any discussion? There's no sidebar conferences. All right. Is there any discussion? Anybody want to speak?
Dan Gray is here.
Family group, laws in favor of it, okay. Any discussion? Yeah, all right, all in favor of the motion, is there a motion? Moved and seconded to report the bill, Senate Bill 455. All in favor vote aye, all opposed no.
Ayes 15, noes 0.
I'm on a roll here, okay. Would like to go next? Senator Lucas. Senator Lucas's bill is Senate Bill 623.
Yes, sir, Mr. Chairman, co-chairs, and I will condense what I was originally scheduled to say. But Senate Bill 623, the goal of this proposal is to allow for more efficient remittance of fines and fees imposed by a court as a result of the criminal conviction for individuals granted clemency by the governor. As current law stands, the governor or the petitioner must petition the court for a certification of fact or a formal opinion on if the fines, fees, and/or interest deserves to be pardoned. The court's opinion must comply or accompany the petition before the governor can make a final pardon decision. Yet the governor has the power to remit the fines regardless of the court's decision or opinion. Eliminating this requirement will enable pardoning of fines and fees to be processed more efficiently, thus helping more families and individuals facing insurmountable debt due to fines and fees that they will not be able to pay off in their entire lifetime. And Mr. Chairman, I have some background information here if you would like for me to keep going.
Go ahead. Is there any opposition to the bill?
Not to my knowledge, Mr. Chair.
Okay, if there's any opposition, speak up. Okay, if not, is there a motion? Moved and seconded to report Senate Bill 623 of Senator Lucas. All in favor of the motion vote aye. All opposed vote no.
Thank you, Mr. Chair, members of the committee.
Ayes 11, noes 4.
11 to 4. We're on a roll. Okay. Yeah, is there, Deej, you want to do your bill? Okay. Okay, we still have a couple of Senator Peterson bills. Where's he? Okay. Bye for the day. Okay. Any other bills we have to hear today? What? 349. Where's that?
I thought we went back for the day.
You want to do your bill? It's three.
What about Senator McCullough? She had to take her spot today. Take some time.
All right, Senator Searle, you want to do 349, Senate Bill 349, Division of Marital Property? Okay, retirement income. Okay.
Yeah, 349, Mr. Chairman.
All right.
349, it's pretty straightforward. So, there's basically two kinds of pensions, speaking broadly. There's defined benefit and defined contribution. Defined benefit, is like a formula. Defined contribution is like a 401k.
Can everybody hear? Go ahead.
And when you divide this in a divorce, you have to enter a qualified domestic relations order, which gives direction to the plan about how to divide it. And so what you usually do with like a 401k style plan is you say that the marital balance as of a certain date is like this much money and divide it in half or divide it however. And the problem is there's a delay between when you agree on the value to be divided, when the qualified domestic relations order is entered, and then when it's actually processed. And so the way you mitigate your risk to your client in that is that you say that the plan administrator has to calculate gains and losses on the amount that the person's supposed to get between the date in the order and the date the money's actually distributed. So if the stock market goes up and down, the plan administrator adjusts the amount by the stock market gains and losses. The problem is VRS refuses to do this calculation. In my experience, most other plans like Fidelity or Vanguard or whatever, they'll do it, but VRS refuses to do it. And all this bill says is that VRS has to do it for VRS-administered defined contribution plans. And then it has an enactment clause which says that VRS needs to ask any localities that have their own special plans what their practice is and report back to us. It's my understanding there's only about 5 or 6 or maybe 8 plans in the state that don't take VRS, like Fairfax County has one, I believe Arlington might, but I'm just trying to get a sense of other localities that might do the same thing.
Okay.
And I've run it by VRS, and they're not happy about it, but I think they said they could comply with it. I don't know if they're here or not, but it's bill basically only affects
Does
VRS.
anybody want to speak in favor of the bill first? Anybody want to speak against the bill? Okay, Family Law Coalition.
Mr. Chairman, members of the committee, the Virginia Family Law Coalition supports Senator Surville's bill.
Okay.
Thank you.
Anybody else want to speak in favor? Anybody want to speak against the bill? Motion has been made to report the bill, and there's, yes, Senator Stewart seconds the bill.
Mr. Chairman,
Senator,
is this VRS?
Senator.
Shouldn't we hear from VRS?
Open chain, yeah, VRS coming up. Yeah, I asked earlier if anybody's against it. What's VRS's position?
Mr. Chairman, members of the committee, we don't oppose the bill.
Okay.
I just wanted to clarify that we were working to try to change our forms so that we would be able to do this.
Okay, all right, thank you. The motion been made and seconded to report and re-refer to finance, correct? I thought somebody said they were, okay. Motion made and seconded to report the bill, which is Senate Bill 349. All in favor of the motion, vote aye. All opposed, no.
Ayes 15, no 0.
15 to no. Okay, 15 to 0. Motion passes. The bill passes. Okay, is there any others that we can take up real quickly? If not, okay. The meeting's adjourned.